Hi, I'm Matt Lockaby. I'm the managing partner of Lockaby PLLC here in Lexington, Kentucky. We represent employees and employers in nearly every aspect of labor and employment and workplace law. For employees, we review and evaluate all types of employment-related contracts, like employment agreements themselves, non-compete and non-solicitation agreements, as well as severance and separation agreements, which is what we're going to talk about today. Now, what is a severance or separation agreement? It's just a document that governs the separation of employment between an employee and his or her employer. Separation may come about because of the employer's termination of an employee. It may be the result of a mutual parting of ways between them. And of course, it could also be the result of a corporate reorganization or a group layoff or a reduction in force, perhaps a plant closure. But in a garden variety severance agreement, the employer will offer a benefit, usually in the form of wages to which an employee is not otherwise entitled, in exchange for the employee's release or waiver of legal claims that he or she might have against the employer. The most common question that we get from employees who have received a severance agreement is whether or not they can negotiate a higher payout or an enhanced package. And the answer, unfortunately, is that it depends. And what we have found are two general rules of thumb. The first rule of thumb is that if an employee has a valid and viable legal claim against the employer, say for discrimination or retaliation or for unpaid wages, the more likely an employer will be to negotiate the ultimate terms of that severance agreement, including the amount of money that might be paid out as part of that agreement. The second rule of thumb is that the fewer employees that are involved in the separation, the more likely an employer is to negotiate those terms. For instance, if it's just a single termination or layoff of just one employee, maybe two employees. But the more employees that are involved in the separation, such as through a corporate reorganization or plant closure or a group layoff, the less likely that employer is going to be to negotiate the final terms and conditions of the severance. Remember, these are just rules of thumb. Every set of circumstances surrounding every separation is different. What your options might be, what you can expect when faced with a severance agreement, will be determined on a case-by-case basis after consultation with an experienced labor and employment lawyer. What should an employee be looking for in a severance agreement? Well, there's a lot of boilerplate, a lot of legalese that is a part of these agreements. But in general, there are 5 things you really want to be on the lookout for when you first take a look at your agreement. The first thing you want to look at is how long you have to consider or review and sign the agreement. Most agreements provide for a period of 21 days to review it and to find an attorney to help you review it. The reason for that, it's not a happy coincidence. Federal law requires that in order for an employee to waive an age discrimination claim, the employee has to receive 21 days to review and consider the severance agreement. Because most severance agreements contain a waiver or a release of age discrimination claims, the agreements provide the employee with 21 days to review the agreement before signing it. Sometimes employees might be given up to 45 days, which is required under federal law in the event of a group layoff. Of course, no time period is necessarily required. We have seen agreements where employees have as little as 24 hours or perhaps a week or so. That's permissible under the law. However, it just means if there is a waiver of an age discrimination claim within that provision in the agreement, that waiver won't be enforceable. The time limit, regardless of how many days you have to review the agreement, starts at the time that the employee receives the agreement. So don't waste time. Contact a labor and employment attorney right away. The second thing an employee would want to look for in their severance agreement is whether or not the employer is asking them to sign a non-compete or non-solicitation restriction. You'll want to know how the employer is trying to restrict your employment in the future. for what duration, in what geographical scope, and in what capacity. We have so much experience representing employees with the review and evaluation of non-compete agreements and non-solicitation agreements, and we've drafted a number of these agreements for employers, so we can meaningfully discuss with you what the proposed language means for you and your future employment prospects. Again, this evaluation process takes time, so contact a labor and employment lawyer right away. The third thing an employee would want to look for in a severance agreement is for language stating that the employee is not waiving his or her claim to unemployment insurance benefits, and whether the employer is agreeing not to contest any claim for UI benefits. Under Kentucky law, an employee can't waive a right or a claim to unemployment insurance benefits in a severance or separation agreement. However, language stating that the employee doesn't waive that claim and that the employer won't contest any such claim is helpful for setting expectations for that process. Fourth, is there language in the agreement setting forth what an employer will tell future prospective employers? This is commonly referred to as a neutral reference provision, and what it does is it sets out what an employer may tell a prospective employer in the event that it receives a reference request. Most commonly, under a neutral reference provision, an employer will agree to confirm dates of employment, the employee's last job title or position, and if it's requested, his or her salary. Employees shouldn't view a neutral reference provision as somehow limiting an employer's ability to say good things about the employee, as this is generally the policy for most employers in most industries, to simply confirm employment, their title, and their salary. Fifth, and finally, an employee should look to see how the benefits will be paid out and how they will be treated under the severance agreement. For instance, sometimes benefits are paid out as wages over the course of a normal payroll schedule. Other times, benefits are paid in a lump sum after the severance agreement is signed. This has an important consequence for taxation. Lump sum payments under a severance agreement are generally subject to supplemental wage withholdings, which is a slightly higher amount of withholding than your standard W-2 wages. Depending on the situation, say the circumstances governing the separation, specific facts about the employee or employer, or perhaps specific issues related to the industry itself, every situation is going to be different, and it highlights the need to contact an experienced labor and employment lawyer right away. If you've been presented with a severance or separation agreement, let's connect because we can help. You can call us during normal business hours at 859-263-7884, or you can email me at mlockaby@lockabylaw.com. If this video has been helpful for you, we hope that you'll click the like button and subscribe to our YouTube channel. For other helpful content, you can find us on Facebook, Twitter, Instagram, and LinkedIn. Just search for Lockaby PLLC and hit the like or share button. We'll see you next time. Bye for now.